Okay, and now, good morning, everybody. Welcome to the now. Can I first ask everybody to please switch off their microphones and their videos so that we can start the morning and it can work well for everybody. A very warm welcome to the European Chamber webinar Wednesday. And it's good to have you all here. We've got SLKB here this morning who's going to empower us to be ready for the POPI Act that kicks into legislation from the 1st of July. Now, just some house rules before I hand over to the Vice President, Francisca Lopez. Please, if I can ask all of you to keep your microphones off and not and your videos as well. Towards the end, when you've got questions, you can either post them in the chat on, and then we will manage your questions. However, if you do want to speak to anybody directly, put your hand up, and then we'll allow you to unmute yourself and put your video on to ask the questions to one of our speakers. A very warm welcome to all of our board members and a special welcome to one of the representatives of the Netherlands Embassy. And I cannot continue without thanking my colleagues from the Swiss Chamber, Eve from the Italian Chamber, Pamina, welcome, and to all of your guests. It's good to have you here. And without further ado, I'm now going to hand over to Francisca Lopez, the Vice President of the Spanish Chamber of Commerce, to introduce our speakers to you this morning. Francisca?
Good morning, yes. Thank you, Manuela, and good morning, everybody. A warm welcome today to all of you who have registered and are eager to learn more about the POPI Act. We have today with us Fernando Lengert and Heiko Braun from SLKB, the attorney company who has been assisting the chamber actually now for a number of years. They have been very loyal members of the chamber and always ready to assist us when we have quick questions to be solved. So I really appreciate that they step up and decided to do this webinar as we learn more about the POPI Act and how can we protect our personal information, but also what can we do as businesses and as organizations to protect the personal information that we are handling from our members, from customers, from all the people we relate. So I think without further delay, I would like to welcome Fernando and Heiko, who will walk us through the intrinsicalities and will try to make us understand a little bit better the Personal Protection Information Act, which will be coming into enforcement from the 1st of July. Fernando, welcome.
Thank you. Good morning, everybody.
Good morning.
Good morning.
Okay, we're ready to start.
I would like to give you the floor now to start the presentation. So please,
thank you
again for joining us and welcome.
Okay. Good morning, everybody. So today we'll be presenting the discussion of are you ready for the POPI Act? And essentially, as was already said, the POPI Act comes into operation on the 1st of July 2021. And this discussion is to see, are you ready for POPI? Are you ready for what's coming? And how, if not, how can you get ready and what needs to be done? First of all, I included this slide right at the beginning of this presentation just to say, keep calm. You're with SLKB attorneys. The message is simple. Everything will be all right. POPI is manageable and it is a good thing, as we'll explain as the presentation goes on. Okay, so the first question that obviously comes to mind is, what is personal information? I myself have attended a number of these presentations on POPI to see what is being said in the industry, what is being said about this. And most of the presentations I attended myself, not one of them dealt with the definitions of the Act and to say what is personal information, what
Sorry about that. We seem to have lost our speaker. One moment, please. Fernando.
identifiable existing juristic person.
Fernando, sorry. Can I ask that you repeat that because you went into mute? If you can just go back one slide. Thank you very much.
Not a problem. Where did you lose me?
Just from the beginning of this. So if you can just start it at the beginning. Thank you.
Okay. So if I go back to the first slide, the message that we're trying to present today with regards to POPI is that we need to keep calm, that POPI is manageable, and it is something that is not only manageable but also a good thing for us and for businesses alike. So the first question that comes to mind with POPI is, what is personal information? Now, if we look at the definition of personal information in the Act itself, and we break down the wording of what is personal information and who it applies to, personal information means and relates to identifiable living natural persons and, where applicable, to identifiable existing juristic persons. So obviously, if we break it down, like I said, it has to be identifiable to a specific person. If, for example, you store your data in a manner or in a system that actually contains no names or any identifiable characteristics, that information itself is not governed by POPI. Another interesting bit of information is that it also applies to information about a company. Now, the reason for this is that most information or personal information about a company would generally include personal information of individuals as well. The remainder of the definition of personal information then goes on to explain what types of information are covered by the definition. Now, I'm not going to read the whole definition here, but the slides will be provided to you after this webinar. But the essence of the definition is that the definition is very wide and all information is included. A simple look at the definition will show you that it includes things like race, gender, sex, pregnancy, marital status, employment history, criminal records, identifying numbers like IDs, emails, physical addresses. So generally, the definition is very wide and covers most information that is collectible about a person. Now, information that is in the public sphere, for example, with CIPC or with the deeds office, is not considered personal information and is not protected by POPI. Neither, for that matter, are court orders or judgments, as they are readily accessible by the public. Now, a question that comes to mind to me when I see this is, for example, information that's on social media or Facebook or something like that. Mm-hmm. I had a situation not too long ago where a client was essentially defamed on Facebook because private and personal information was published about him. Now, the argument from the other side at that case was the information was already on Facebook before they had shared it, but that information itself was published without his consent. So the fact that the information was already out in the public sphere does not mean that it's not governed by POPI, and it does mean that you cannot share it unless you have permission to do so. So everybody must naturally be very careful with situations like that on the one hand, public information is not governed by POPI and can be shared, but if it's there by accident or without a person's consent, then it becomes an issue that POPI will govern that situation again. Now, the next definition in the POPI Act is who is a responsible party, because naturally it always, the Act deals with personal information, and it constantly then mentions responsible parties. Now, a responsible party means a public or private body or any other person which, alone or in conjunction with others, determines the purpose and the means for processing of personal information. Now, the key word here for me is processing, because obviously it applies to everybody, and with the keyword being processing of who in the country or as a company or as an individual process that information. It's not sufficient to just say that everybody's governed by POPI. You must actually be dealing with and processing personal and private information of other people before the Act applies, and that's where you become a responsible party. Now, how does POPI protect citizens? POPI's purpose is to give constitutional right to privacy by protecting personal information. It doesn't mean, however, that all information is private and all information is not subject to being shared or disclosed. There is a balancing act between the right to privacy and the right to access to information. Now, I'll deal with it later in the slides with the Promotion of Access to Information Act, which also then ties hand in hand with POPI and how information is to be dealt with and processed. So there's two conflicting rights, the right to privacy against the other person's right to access to information. POPI also regulates the way in which personal information must be processed. It provides rights and remedies for transgressions and establishes the information regulator. The information regulator obviously will ensure that those rights are protected, and in future will deal with specific cases and give ordinances or notices on how this will take place in future. Okay. POPI does not mean the end to direct marketing. It also does not mean that spam will end. With regards to direct marketing, though, there is a distinction that's been drawn now between new and existing customers. So, for instance, everybody would, or most companies in South Africa would already have an existing database of its customers and clients. So the details of existing customers who are obtained in the ordinary course of business, either to sell products or to market those products that a company sells, no consent is required. But the customer is always given a reasonable opportunity to object to being contacted or to be marketed to. New customers, on the other hand, must give consent before marketing is permitted. And now there is obviously a bit of an argument about whether, how or in what form this consent must take place. There is a distinction between the opt-in and the opt-out form of consent. The opt-in is obviously where you go onto a website and it says click here if you want to receive information, and that is an opt-in form of consent. An opt-out is where you have the tick box, but the tick box is already ticked for you to say that yes, I do want to receive the information, and if you don't want to receive it, then you have to unclick it. So it's opting out of that consent. Now, in relation to new customers, they are both permitted, but at this stage, obviously, we don't know how it will be dealt with in future. But in order to be safe and to ensure compliance, the opt-in approach is a safer option and should be followed in future. The information regulator will obviously have a final say once cases are brought before her, and obviously some case law will be developed at that stage. So at the moment, like I said, both opt-in and opt-out forms of consent are permitted, but it's probably more likely that the opt-in will be the one that will be required in future. Okay. Then we deal with once you have personal information of a person, can you then pass that on or share that information to other parties? Now, one of the major issues is cross-selling. So that is where you've got company A and company B in the same group of companies, and they sell different products. Now, company A has the details of a person for a specific purpose, which he has consent for, but he wants to pass that information to company B, so that company B can now also sell its products to that person. Now, this essentially is not allowed. There are obviously ways around it, but there was an interesting case a few years ago between Blacksash Trust and the Minister of Social Development, which dealt with the payment of grants, which was quite big in the media a few years ago, with obviously the allegations that were labeled against the payment services and how they acquired those contracts. Now, what was interesting there is you had the one company which had attended
Fernando?
decided that personal data obtained in the payment process. Am I still on?
Yes, you are. Thank you.
So personal data which was obtained in the payment process, so for the purpose of payment of those social grants, may not be used for any other purpose other than the payment of those grants. So when they took that further step and shared that information with their sister company, that was not allowed and probably will not be allowed in future. But as I said, there are 8 conditions for lawful processing, which I will just explain briefly. The idea is that if you do pass on that information, accountability still remains, and the responsible person must ensure compliance with the Act. So if you pass on that information, the other party or the receiving party must still be compliant with the Act. Personal information also may only be processed in a fair and lawful manner, and only with the consent of the data subject. Now, in that Black Sash case, there was no consent from those individuals concerned. Personal information also may only be processed for specific, explicitly defined and legitimate reason. Personal information may not be processed for a secondary purpose unless that process is compatible with the original purpose. The responsible party must take the reasonable steps to ensure that the personal information is collected is complete, accurate, not misleading, and updated when necessary. The data subject must also be aware that you are collecting the personal information and for what purpose that information will be used. The personal information must be stored safely, and the data subjects may request where the personal information may request how their personal information is held and ask for correction or deletions to that personal information. Okay, now to focus on some of the areas for compliance, firstly off with a joke, which I know not many people would appreciate, but compliance is essentially like going for colonoscopy. Nobody wants it, nobody wants to talk about it, but once it's done, you feel better. And for a more simple approach, it's the same as going to the dentist. It's not bad, and it's actually good for you. And once it's done, I think everybody will be the better for it. Okay. Now, why do we need to comply with POPI? POPI compliance is essential for the well-being of any company in South Africa. Now, in this post-lockdown world, trust in businesses has reached such a level of importance that it is almost the most important thing any business has, or as an asset to its business. Now, any data breach that happens or unsolicited phone call that is received by a person is going to break that trust. So in this world where business is now so tough, and every little avenue that we can use to the benefit must be used and must be protected. So the trust in the business is one of the most important things that any company has. Now, it is estimated that each breach of data, so where data is stolen from a company, can cost millions of rands. Now, I don't myself know how that estimates are arrived at, but I think the real important point is that data breaches destroy the trust that a customer has in a particular brand or a company, and sometimes it can just never be restored. Now, what if I cannot afford to comply with POPI? Compliance with POPI is not expensive, and it should not be seen as it's not an expense that should be seen as something that I have to do, but should rather be treated as an investment in your company. POPI requires your business to use personal information for the purpose for which it is collected, to be stored safely, and to ensure that that data is up to date and accurate. Now, if you just think about that, if you're basically being required to make sure that the information that you have about your own customer, to the most part, is up to date and accurate. Now, that can never be a bad thing. If, for example, you deal in a business where you're required to make deliveries to your customer, or even send your products via a courier company to your customer, having the correct information, the correct address, is crucial to making sure that you are able to complete that transaction or comply with the contract. So it should always be seen, yes, it's difficult, and yes, it is time consuming, but it can never be a bad thing. It always must be seen that this is a good thing, a step in the right direction, and having this information readily on hand will help your business complete its transactions. It'll help it complete its sales, and can only be a good thing for the future. Safekeeping of the data is a must, obviously. And as I said, having the accurate data for the business will help you market to your customer and to complete sales and transactions. Now, is there a difference between small and big business compliance? And in theory, no, there isn't. But naturally, for a small business, compliance would be easier, because it's just a simple fact that they would have less data and less people having access to the data. With a big business having more data and more people accessing that data, there's more things that can go wrong. But the consequences for non-compliance can obviously be more drastic for a smaller business, because, as I said, trust is one of the more important things. And if with a smaller network or smaller base of customers, if your trust is broken and you lose your core of your customer base, that will have a more drastic effect, where a larger corporation might be able to absorb those losses more easily. But at the end of the day, it is as important for a Vodacom as it is for the local shop on the corner, because this if you have the information, you must make sure that you keep it safely and make sure that it is processed correctly. Now, again, I just touch on this issue of sharing of personal information between groups of companies. Sharing of information between groups of companies can be made POPI compliant by ensuring that the data subject knows will be shared, and that is informed of the purpose of sharing this data. Again, I note the Black Sash Trust case, but I think it's imperative that some exercise must be taken to inform customers that either right at the beginning, at the start of the relationship, that this information will be collected and shared, or if the relationship is already existing with customers, that they are now notified that this could take place in future. Okay, then the major issue or the major requirement right now is the registration of information officers. So just to explain a little bit about where this role of information officer comes from. Although under a different name, it was essentially a role that was created by the Promotion of Access to Information Act. POPI has expanded on this role and the definition of what an information officer does. I will go into more detail about POPI in later slides, but at the moment, PIA, which is the Promotion of Access to Information Act, requires private companies to have the CEO or the head as its information officer. The head can be quite a vague term, so in essence, it should be somebody in control of the company, so the CEO, managing director, or someone at that level. It is recommended thus that the CEO, head of the company, is appointed as the information officer, and that he or she then appoints one or more deputy information officers. This also does not absolve the CEO or the head of the company from his or her responsibilities, and would maintain an oversight role over those deputy information officers. Those deputies would be more hands-on, run the day-to-day things, and then report to the CEO when necessary. Okay, the main functions of an information officer is obviously to ensure compliance with POPI. It is dealing with requests for personal information. So this is important because, as I mentioned, with the Promotion of Access to Information Act, outside parties are entitled to request personal information that you hold about other people. So if such a request comes in, your information officer would be the person to deal with that request and decide whether or not that information can be shared. The information officer work with the information regulator in the event of an investigation. Now, hopefully this will never come up, but that is one of the roles that is required. And then it's ensuring and encouraging compliance. So what is compliance? Compliance would essentially mean developing information governance strategies, analyzing privacy regulations, advising and consultancy on privacy, privacy training and communication, monitoring privacy compliance, responding to privacy incidents, reporting to management, so again, the CEO, and privacy risk assessment and data inventories, and developing and implementing privacy policies and guidance. Now, this little expert or definition here is essentially what should be in any information officer's job description. So a lot of people, I think, are asking the question, do we need to hire somebody new to take this role? And the answer is simply no. There should be, or there most likely is in every organization, some person who is really perfect for this role already in the employment of a business. It's just a simple case of identifying the correct person and giving these duties to them. But like I said before, it is always going to be the responsibility of the head or the CEO of the company. So it's just a case of the CEO or the managing director or similar person taking responsibility and delegating these functions to a deputy that will deal with these day-to-day duties. Okay, so POPI and PIA are essentially, as I said, two complementing acts, but also very opposing acts, in the sense that one requires personal information to be kept secret, the other one requires access that personal information held by companies or individuals. So PIA sets the framework for allowing access to information held by the state or private bodies, companies in this case, and that is required for the exercise or for the protection of any rights. Now, POPI essentially reiterates the requirement for private and public bodies to have a PIA manual. Now, I'm sure everybody remembers the mad rush a few years ago to have these PIA manuals drafted and to be put on your website. It's still a requirement. It's still a must. And essentially what PIA has done now is, POPI, sorry, is they've reiterated this need to have these PIA manuals in place, and they've also gone and amended the wording that needs to be inserted in those PIA manuals. So if you do not have a PIA manual, you will have to not do that, and it might also require an amendment to that PIA manual. One of the changes that POPI has introduced as well is that POPI and PIA will now be enforced by the information regulator as one or under one umbrella, essentially. PIA used to be enforced by the I think the Human Rights Commission. Now it will be dealt with by the information regulator, which makes sense, obviously, as the two are quite intertwined. Okay, so that concludes my part of the presentation. If I can just now hand over to my partner Heiko, who is sitting right next to me.
Good morning from me as well. Thank you very much, Fernando. I just want to continue where Fernando left off. For now, the POPI audit is essentially where the cookie crumbles, where action is required for companies currently. The question is, are companies POPI or POPI compliant? Just a little bit from myself. I like to refer to the Protection of Personal Information Act as POPI because I think it sounds cooler. A lot of people use the word POPIA, but obviously for this presentation and also within the realms of POPI, those two are synonyms. So what needs to be done within the framework of a POPI audit is that initial risk assessment needs to be done, which needs to basically look at the flow of information through a business. And then after that is done, one needs to assess risks. If there is a non-compliance with the POPI Act through the flow of information through the business, then one needs to find a solution for these non-compliances, and these solutions needs to be implemented. So as time goes by, there will be courts and there will be the information regulator that will make POPI a bit more, will put a bit more flesh to the bones of POPI, because this act was created pretty much in a vacuum. So we don't really know how the regulator and later courts will interpret this act. That's why it is important that one does not do one POPI audit, implements one set of solutions, and thinks that that is it. As time goes by, the POPI internal procedures and processes must be reviewed and must be adjusted. And that is why it seems to me that maybe attorneys and IT specialists lobbied for POPI to be implemented, for these two groups to get continuous work. But the aim should be to get the initial processes and procedures in approaching POPI compliance so well established that with a few adjustments as time goes by, one still and remains POPI compliant. Okay, so in a POPI audit, what questions should we be asking? Well, obviously the right ones. We need to establish what personal information do we have in our business? What do we use it for? Do we really need it? And do the data subjects know that we have their personal information, storing it, processing it, using it? Do we have comprehensive policies and procedures on how to deal with personal information within our company? And within this framework, consent is king. So if the data subjects know exactly where their personal information is and what it is used for, and they have consented to that storage and use, there is not many issues with POPI compliance at this juncture. So then there is a question of whether it's possible to de-identify the personal information, meaning making it anonymous. If we need personal information in our businesses for statistic purposes, just to establish the market for a product in certain age groups, for example, do we need to store the name and addresses, or is it enough to just have the age, the birth date of a person, just as an example? And then physically, is the information held securely? So if we process documentation in our company, do we print out that documentation, put it in a tray, and at the end of the day, when the person processing that information takes the tray and puts it in a normal paper bin for anyone to go outside when the bin is out to have a look what's happening, that might be a problem. So rather err on the side of caution, identify this and deal with the hard copy information in a POPI compliant way. And then what is also important, if we in our business are audited by the information regulator, we need to show what we have done with information. So we need to keep a record of our processing activities. Key to that is that one chooses the right team of experts internally and externally. So this might probably not be the right team. I just have to explain. There is no way that we at SLKB can do a presentation without some reference to football. Since I am German and we're dealing with the Spanish chamber, among others, I thought this would be a good example. So in November 2020, Germany lost 6-0 in Spain. And the Germans had players in their team that are well established. Toni Kroos plays for Real Madrid, won the Champions League 4 times in a row. So you would expect he's doing a good job. You don't have to worry. While in the Spanish team, there was a youngster called Ferran Torres. He scored 3 goals. I think this was his second game for the Spanish national team. So while I'm saying that is, if one looks at the team that one essentially wants to work for one's POPI compliance, then one should probably look that one puts the right people together. So for example, my 75-year-old father, who is a lovely guy, but who doesn't do technology, is probably not the right person as the information officer. Again, individual parts don't make a team needs to work together. So with POPI, another reference to the 80s, it's never a one-time, once-off, one-size-fits-all solutions. It's an ongoing process. So essentially, with what you have, with what you need to MacGyver your appropriate solutions for your business as your business evolves over time. This means also that the people that work for you will know a lot about how you process information. You don't need an external expert for every part of your POPI compliance team. You can use your own staff, maybe assisted by experts. So there is one topic within POPI, that's the code of conducts. Earlier this year, the information regulator published guidelines to develop codes of conduct under POPIA. And people were up in arms and panicking, thinking, I have to adopt now this code of conduct immediately. We're not there yet. This step was taken by the information regulator, who had to establish POPI within a vacuum to try to create standards for certain industries. That's all it is at the moment. So over time, the employer organizations of certain industries will establish codes of conduct, and then it would be advisable for your company, not necessarily, how do I say it? It's not mandatory that you adopt everything that your industry establishes as code of conduct into your business. It's just that the regulator will look at what is the standard in a certain industry when they establish how they apply POPI to your business, respectively, if there have been breaches, on how to assess who is responsible for the breach and what the respective remedies should be. I will go through this relatively quickly because you will get these slides at the end. But what I find is important is that you are in contact with the representatives of your employer organizations within your industry, just to make sure that there's nothing that you miss. So since we're dealing with different European chambers, I think it is relevant to discuss foreign companies and cross-border sharing of information in a bit more detail. So what happens if information is flowing through South Africa, going from South Africa to another country, or coming from another country? The aim is to ensure that the personal information remains protected, even if it is outside of South Africa. So there is a lot of very confusing situations in that realm, because data not being physically available, but on the internet, travels freely without borders. So it's very difficult to limit this. So at all times, and you will, if you would look at the POPI Act yourself, you would see reasonable processing dominates this act. So everybody knows that in very many instances, you cannot have clear-cut borders and clear-cut limitations. You have to just do what is reasonable. So in order to assess when is POPI applicable for foreign companies, I would like to discuss a few examples of when that actually becomes relevant. So one example would be if a South African company processes information of Italian residents in order to market maybe to the Italian market, then POPI would be applicable because the company that is processing the information is a resident of South Africa. Another example, if a Spanish company would process information of South African residents, which it collects from a Nigerian entity, from records that are available freely on the internet, then POPI would not be applicable, because neither the company that is processing the information nor the means of the processing are inside South Africa. But if that same Spanish company has a local entity, then POPI would be applicable. Another example would be if a Swiss company processes personal information of South African residents by using a South African operator, meaning, for example, a public relations agency here in South Africa, then POPI would be applicable because the operator, the means of processing, would be in South Africa. If a South African company uses Italian servers to store private information of its South African customers, then POPI would also be applicable because the company processing personal information is residing in South Africa. If an Italian company sends personal information through a South African server to Switzerland, then POPI would not be applicable because it would just be the traveling of information through South Africa. So we will see how this specific topic continues to develop once the information regulator and the respective courts in South Africa have to deal with cases where breaches occurred because of the flow of information in and out of South Africa. The European General Data Protection Regulation, which has been established in 2016, and POPIA or POPI, it can be said, and that it's very evident in the protocols of the regulator when they established POPI. POPIA basically flows from the European General Data Protection Regulation. There is a lot of similarities. There is one very important difference. In the European General Data Protection Regulation, it's clearly defined that personal information refers to information of individuals, whilst POPI also protects the information of juristic persons. So just before I finish, and it's not on the slides, a friend of mine who has worked extensively in the field of POPI even before it was established, and who has been in contact with the regulator quite frequently, said to me that it is the general idea that the regulator in the beginning of, or from the 1st of July, is not out to penalize companies and to try to extract money by means of inflicting a penalty on the companies, but rather to issue compliance notices to have the companies in South Africa become POPI compliant. So that's why we would say, don't panic. But the European examples that we have for penalties also leaves us with a little bit of a headache, because there is a potential for relatively heavy penalties and measures that can be posed onto a company. So in Europe, the Information Commissioner's Office has fined British Airways at the end of last year, I think in November, £20 million for a data breach that affected over 400,000 of its customers. So we must be aware of this, and we must put the right measures into place. So then there's questions that remain. Can you manage to become POPI compliant yourself? Do you need assistance? Yes, you can manage yourself, and no, you don't need assistance. Nobody forces you to hire experts to become POPI compliant. But should you do that? In our field of work, people sometimes ask us, can I sue this person myself at the magistrate's court? Yes, you can. Can you get divorced without the help of an attorney? Yes, you can. But do you really want to do that? I liken it to the question of, must I do my own plumbing? I can probably do that, but sometimes then it might drip from the walls. So I just want to end with this, and we're looking forward to your questions.
Thank you very much, both to Fernando and Heiko. and we've received quite a number of questions. Some of them have been partially answered. Frantisca, before I start reading any of the questions that have come through, would you like to make a comment here, please?
Well, I think, can you hear me? Sorry. Yes, thank you very much, Fernando and Heiko, for this presentation. I know the topic is very extensive and the topic is also very new, which means we will need to see how the courts react to this. But for us, I think the most important thing is that we, for example, from the chamber, know how to protect the information of our members, what we need to do in terms of, exercising due diligence and being always very careful with the information that has been entrusted to us. And I think this would be basically my take of the responsibility that we have as responsible parties when we are managing and processing information that relates to our members and the chamber. We need to ask for consent, and we need to be extremely responsible and careful when we are processing that information, making sure there is no breaches and that we all know that we are being extremely careful with that information. So I think that's basically my take. If you have something to add, I would ask, is there something else we need to do in terms of the chambers? And I see some of the chambers are here with us, the Swiss chamber and the Italian chamber. What would you advise us? What must we do in terms of adhere to the POPI Act regulations, and how can we ensure that we are acting in compliance?
Thank you very much.
Sorry.
Okay, just to add to what Francisca has added, Pamina from the Italian Chamber of Commerce posted up front, if public information is not protected, is a Chamber of Commerce allowed to sell a service to a foreign company whereby the Chamber compiles a list of details of SA companies in a specific sector? For example, an Italian supplier of mining equipment wants to purchase a list of mines with contact details of procurement managers. So what do the chambers, they can look onto Google, they may have certain databases, etc. How do they manage this process and not to get into trouble? Because we're not only having to comply right now with the POPI Act, but as European chambers, also the GDPR Act as well.
Yes. Well, I think in terms of POPI, the answer for chambers would be quite simple, or in the sense that most chambers would be treated almost like a subsidiary company having a head office in Europe. Because my understanding is the chambers obviously have to send reports to Europe, which would include a lot of personal information. So that would include having to not only worry about the issues of POPI, but also the GDPR and the specific requirements of sending that information overseas. So the first element being that if you send information overseas, you must make sure that the receiver is either governed by a similar act or with a binding agreement that says that they will be responsible for POPI. Now, with all the European countries, that's already covered. The second point would be that the receiver of that information overseas is also then bound not to on-share that information, which is also covered. So in that regard, at least the European chambers are a little bit more protected. With other chambers for other jurisdictions, it might be a bit more tricky. But essentially, that's how our chamber needs to operate and think of itself as a company that has its headquarters in Europe and must try and follow those similar requirements. Now, with regards to collection of information, my understanding that this information to be collected is on a public platform like Google, which then means would not be covered by POPI. However, it might also just be a safer option that if it's possible to get consent of those people that you're collecting the information, because on the one hand, it would allow you to contact those people. it would allow you to make sure that the information you collect is accurate and the best information you can get, because at the end of the day, whatever you acquire of Google might not be accurate and might not be 100. It's advisable, okay, let's actually, instead of just relying on what's out there on Google, is to contact the data subject directly and say, listen, what information can you give us about your company? And then obviously just treat that information with the knowledge of where it's coming from as well.
If I may add to that, the attorney's usual statement applies here. It really depends. So if you just compile a list of companies which you have sourced from the company's websites, you should be okay, because then why do the companies put their websites onto Google or onto the internet? Why do they go out there? They want to attract traffic to their website. If you, as you further elaborate in your question, then call the switchboard and try to get the person sitting there to give you more detailed information that you cannot find on the website, then you're probably going into a bit more of a gray area. So there I would agree with Fernando to say, in case of doubt, try to get their consent. And if you would call a mining company while you're speaking to the person at the switchboard and they connect you to the probably to the procurement officer, he would probably not mind that if you put the information of the company out there for Italian companies to market. That would be my take on this. And that would probably also tie into POPI compliance essentially becoming a tool for you to market your business.
Okay. Thank you, gentlemen. The next question is from Daniela Pellegrini. How will POPI affect shareholders of a private company wanting to view the share register?
So the situation is actually governed by the Promotion of Access to Information Act. So if we have regard to a standard PIA manual, it actually contains a form which you simply complete and send to the company and request that information. They are then required to give you that information, but obviously now with POPI coming into effect, the company must just identify whether this request is reasonable and decide for itself how much information it can share. So I often have it as an attorney where I need to institute legal action against the company. I sometimes do need to know who the shareholders are. And with that, I need to send a request to that company requesting that, because in the olden days, this used to be public information that was stored at PIPC. It's no longer the case. So now if I need to know who the shareholders are, the best place for me to ask is to ask the company itself. And essentially that information is shareable, but it has to be shared in line with POPI. So for one of the requirements of POPI is that where you can minimize the effect or minimize the amount of information that you store or share, you must do so. So it's just a case of when you receive that request to identify what actual information is being requested and how little can you share. So the less is better, obviously, in this regard. If you, for example, have addresses and cell phone numbers of shareholders, you probably shouldn't share that. You should probably just share the names and whatever else is requested, but try and share as little as possible. But again, a lot of these things are case-by-case basis, and it does depend on the actual request received, the information had, and if the information regulator has given any guidance notes on the subject or not.
Thank you very much for that, Fernando. From Liz, is an annual report of a listed company in the public domain, or is this detail protected by POPI?
I would say no. if obviously if the information is already out there in the public sphere, so it's a public company, it publishes its annual results, then the information would not be covered by POPI and would be shareable. It's also interesting on the subject is how do journalists deal with this information. Now, the idea that POPI, for example, is not there to stop journalistic freedom and freedom of expression and those kind of things. So it'll be interesting. But the idea is that if it's in the public domain or if it's in the interest of the and again, does the information or has the information regulator provided any guidance on this topic, yes or no?
Okay, thank you very much. Daniela has 3 questions. The first one has already been answered by you, gentlemen. Thank you. Her second question is, companies need a privacy policy that informs data subjects about what info is collected, how it is used, processed, and the data subject is right. But do companies need an internal policy, okay, that educates employees on what to do? For example, if consent is obtained, where is that consent filed? And also, if a data subject wants to delete or change details, how do they go about this? And then this third question, maybe you can just keep this together, is where does POPI stand now? There was a deadline for smaller business to have a POPI manual. Is this effective or has the deadline been postponed? Thank you.
Sorry, just to clarify, a PIA manual. I know smaller businesses had a short deadline or a different deadline to everyone else for PIA. And I heard something recently that's moved, but now I'm not clear. So thank you. Thanks very much.
If I can deal with that question very quickly, the deadline has been moved to must take place before POPI kicks in on 1 July. But essentially, most businesses should have had it already with the earlier deadline, but the ultimate deadline is now 30 June. Then with regards to the earlier question about the manual or the policies, I think, yes, it is advisable to have an internal policy. So the idea with the Poppy Audit is that we go into a business, we identify the data or how data is processed within a business, you identify the risks associated to that processing, and then it's about developing those policies and a manual essentially on how that data is then received and processed, and to ensure that those people that are involved in that chain are then trained. It's very important, for example, from a labor law perspective, that if you want to hold an employee responsible or accountable for how they process their data, that employee also needs to be bound by a policy. If that's not in place, then the company may find itself having to deal with a breach and having no recourse against its employees. So it is advisable to have an all-encompassing manual that deals with the policies of how to deal with it, and to ensure that the employees are accountable in the process as well.
If I may add to that as well. So again, here, making your company POPI compliant is, in this instance as well, another step where it can help your company to be a bit more efficient. So for internal policies that basically add on to employment agreements are important for exactly these purposes. So if an employee commits a breach of his employment agreement because he acts ultra-virus, he or she does not do his work properly, then a policy will help you to pinpoint this. And so whilst it's not mandatory to have an internal policy, it is definitely advisable.
Thank you very much.
Especially in light of the fact that this will not go away. This is not a once-off thing. This will be a continuous situation. And as we continue with our life in the pandemic, I think more and more will become more intricate and more virtual. More data will become more important. So even for small businesses to deal with this seems to be important.
Thank you very much, gentlemen. I see there's a lot of questions that are coming in, and we may not get to all of them, but I think what is good to know, as you can see, we've kept this on, SLKB are offering you 1 free hour consultation with regards to the POPI Act after this. So let's carry on. There's 2 questions right now, one that leads into the other, and I'm sure you can see it next to it. From Liz, does the information officer need to specifically register with the regulator, or is it taken that the CEO is the information officer? And then what, and I think what came after that from Colin, I think it was, is if a South African office reports to a head office in another country, the head office already has an appointed CRO in terms of that country's POPI Act. Can that person act as the CRO for the office?
Okay, thanks. What I was thinking is, if we do not answer all the questions, perhaps we can just email the attendees afterwards the answers to the questions we don't get to.
Let the attendees
Absolutely.
email us.
Okay. Yes, okay, directly.
So then with regards to the information officer, yes, registration is required. So it's not accepted that the CEO is automatically the information officer. There is a registration process which has now opened. It's as simple as filling in a form which can be found on the information regulator's website. If you want, Manuela, we can also send you a copy of that form, which can go out to the attendees with the slides afterwards. With the question about an information officer from overseas, to be honest, I actually don't know the answer to this question. The only thing that I can think of is, obviously, if that head office is in a country that is bound to a similar type act, then it does make sense that they already are bound to these provisions. However, I don't think it really complies with the purpose of having an information officer, which requires that a person hands-on and able to deal with requests for information, and B, with say investigations by the information regulator. So to me, it doesn't sound like it's a good idea to have somebody overseas appointed. It would make more sense to have a local person appointed, and if necessary, those local people can report to the head in Europe. But it doesn't seem like a good idea, practically speaking, to do so. But I will look into that after the webinar and see if there is an answer to that question. But offhand, I do not know.
Okay, thank you for that. Pamina from the Italian Chamber has asked, how serious is it to add a person to a mailing distribution list if you have met the person at an event and they've given you verbal permission to add them to your database? Okay, now you can't prove this because it's a verbal request. So the question remains is, we do add them, and when we send things out, all of our emailers have an unsubscriber button for people to actually just unsubscribe themselves to. How does one manage this?
Well, look, in terms of the Act, the consents received are actually supposed to be stored or kept. So obviously, if you have to keep a record of that, it would have to be in physical form. So verbal permission, I don't think would be good enough, but One of the main principles of POPI is that you subscribe. So as I mentioned earlier with the opt-in, opt-out provisions, it would still be okay, bear in mind that it does have an unsubscribe button, but a good solution might be that after speaking to a person, is to immediately follow that up with an email and just say, hi, we met today, and just to remind you, we did this. If the person doesn't respond, I would leave it at that. If he does respond, keep those emails and just store them as a consent.
Thank you. Thank you very much for that. From Liz, if I collect information on a project, say a solar power project, that is taking place in an African country from sources on the internet, the press, company website, etc., and I put this on a database behind a paywall that is available to clients, is this compliant?
Again, I think it's similar to the earlier question. I would say yes, because the information's been collected from public sources. But again, it just ties back to what we were saying earlier, is that if possible, it might be a good idea to contact those subjects directly and just inform them that this is happening. But if the information is collected from online sources, then it shouldn't be a problem.
Okay, thank you.
Online, so from just a second, from online sources that were put out there by the company itself. So if there's a private investigator that makes it his task to collect data and create a website where he or she stores information of companies, and the company is not aware of that, that will change the story considerably. So if it's directly from the company, I would say go for it. Otherwise, be very careful.
Okay. Thank you very much. From Julie, she said, what is the definition of the public sphere, public domain? And then why did the POPI Act not limit its protection to a natural person like in the EU? Why does it include information regarding juristic entities? Most of them have websites.
I think the simple answer is we live in a first world country. But, no, look, the idea with public sphere, public domain is I think it's a difficult thing to define, in the sense of I was grappling with this myself earlier on, is to say, you know, there's a difference between a court order and an arbitration award. Arbitration awards are confidential. So can you share that, or can't you share that? I think at the moment it will require a little bit of wait and see, because we need some guidance from the information regulator to see how they will handle these things. But essentially, like Heiko said earlier, if you're looking for something on the internet and you obtain that information directly from that company's website, then I would say yes, that information is open and can be shared. But if you obtained it from a website where a person might not know that the information's there, then you need to treat that more cautiously. But it is kind of a gray area. With regards to juristic persons, I don't know why they didn't limit it to natural persons, but every time I've looked at this, I actually like the definition, to the way they've done it, to include the juristic persons, because firstly, juristic persons also have reputation. They also have, although they have a website, they might have some information that they don't want to be shared. And we have sort of followed this rule or idea that we will protect juristic persons in the same manner as a natural person, and I think that is a good thing. And also we must remember that most information about a company will include information about a natural person, with the shareholders, the directors, employees, those kind of things. And not all of that is available on a public domain.
Okay, thank you so much. And the last question from Julie, which is quite important, is will South African professional associations no longer make their lists of members available in order to be compliant with the POPI Act?
I'm not sure, but my view would be if they do that, to simply get consent. So I would think, like, for example, us as attorneys, we can be found on the Legal Practice Council website. So I would think that they would continue to do that. It's just about making sure what information are they sharing, and have they got consent from those individuals as well.
Okay.
I think
Thank
it
you.
ties in with Famina's question concerning what if I meet somebody on an event, can I put them on my mailer? I think it's very similar. If you join a professional organization, in the future, I would assume that that professional organization on the documentation that that you need to fill out in order to become a member will have a paragraph where you state that you are actually in agreement with the professional organization sharing that information with their members, or even with state entities, whoever. So I would assume that that will be one of the changes that we will see in the documentation concerning membership.
Thank you. Daniela has a very good question here, and she says it's her last question. Where information is stored in the cloud, like a Dropbox, etc., is it sufficient to refer data subject to Dropbox's security policy? And in reality, no company that uses a Dropbox can actually guarantee the security of the Dropbox users.
Yeah, I would say it's a bit of a gray area, but probably not, because, you know, at the end of the day, you are the responsible party. So if you put the information on Dropbox and there's a leak, obviously Dropbox itself will be one of the companies contacted by the information regulator, but they will come to you as well and ask you, why did you put it on there? But also, I think one of the risks with Dropbox is, for example, you add the wrong party to that folder, then, you know, that has nothing to do then with Dropbox. You have then shared that information. So it is very dangerous, and needs to be treated as such.
Again, here, I think consent is king. If you share personal information on Dropbox, depending on the circumstances, you might want to inquire with the data subject whether the data subject consents to having that information stored in the cloud on Dropbox.
Thank you very much, both Heiko and Fernando. This has been really empowering. Frantisca, would you like a last word here before I thank all of our guests for attending today, please?
Yeah, I would like to thank everybody who attended the webinar. Very special thanks to Heiko and Fernando for guiding us through this process. Very practical questions have been presented, and I think we are now a little bit more sure when we are dealing with personal information. And I would like to refer again to your generous offer. If someone else have questions that have not been posed here, or something comes after the presentation, please feel free to email Fernando and Heiko. They are offering very generously a 1-hour free consultation for the members of the chamber and for all attendees. So I think this is really generous and want to thank you. And again, thank you for everybody who took part in the webinar. And thank you, Manuela, for organizing this.
Thank you so much, everybody. Keep well, stay safe, and you will be receiving an email by tomorrow with all the information. Have a good day. Bye-bye all.
Bye.
Thank you.